financial significance to the director that it would reasonably be expected to influence their vote on the transaction.
So if a transaction involves self-dealing, is it automatically void or illegal? Or can it be made legally safe somehow, even with the conflict?
It's not automatically void, but it is automatically suspect and subject to challenge. However, there are specific statutory safe harbors that can cleanse the transaction and protect it from being voided solely due to the conflict, effectively restoring a level of protection, though not quite the BJR. The transaction can be validated and protected if one of three conditions is met. 1. There's full disclosure of all material facts about the conflict and the transaction to the board, and the transaction is then approved by a majority of the disinterested directors, meaning those directors who don't have a personal stake in the deal. 2. There's full disclosure of all material facts about the conflict and the transaction to the shareholders, and the transaction is approved by a majority of the votes cast by the disinterested shareholders. Or 3. Even without disinterested approval, the transaction is proven, usually in court, to have been substantively fair to the corporation at the time it was entered into. This fairness typically looks at both the price and the process. If any of these three safe harbors are met, the transaction generally may stand, even though it involved an initial conflict of interest. It's all about ensuring transparency, approval by an unbiased body, or demonstrating inherent fairness to the corporation.
Okay, that makes sense. What about the second breach? Usurping a corporate opportunity. Does that mean a director can never pursue any outside business venture if it's even remotely related to the corporation's business?
Not quite that restrictive, but they have to be extremely careful. Usurping a corporate opportunity occurs when a director takes a business opportunity for themselves that should have first been offered to and belonged to the corporation. The key question is, was it truly a corporate opportunity? Courts use a few different tests to determine this.
What kinds of tests?
One is the interest or expectancy test, which asks whether the corporation has an existing interest or a reasonable expectancy arising from an existing right or line of business in the opportunity. Another common one is the line of business test, which asks whether the opportunity is within the corporation's current or prospective line of business. For instance, if a company develops specialized medical devices and a director learns of a chance to acquire a patent for a related groundbreaking technology, that's likely a corporate opportunity within its line of business. Courts also consider factors like how the director learned about the opportunity and their corporate capacity, the relationship between the opportunity and the corporation's existing activities, and whether corporate resources were used to find it.
So if it is deemed a corporate opportunity, what must the director do?
They must first present it to the corporation, typically to the board. Only if the corporation, after full disclosure and proper consideration, usually by disinterested directors, formally rejects the opportunity, can the director then pursue it personally without breaching their duty of loyalty. They can't just secretly take it for themselves.
And the third breach, competing with the corporation, that seems pretty straightforward, right?
It generally is. A director breaches their duty of loyalty by engaging in a business venture that directly competes with the corporation they serve. Their fundamental allegiance should be to the corporation's success, not to actively undermining it by setting up a rival business while still serving as its director.
Okay, those duties are serious. What happens if a director gets sued personally for something related to their role? Maybe for an alleged breach of care or loyalty, or even just for a decision made under the BJR that someone challenges. Does the corporation just leave them hanging, or does it protect them financially?
They aren't necessarily left hanging. Directors may seek indemnification from the corporation, which is essentially the corporate financial safety net for directors facing legal challenges related to their service. Indemnification means the corporation covers their reasonable legal expenses incurred in the action and potentially any judgment or settlement amount against them.
Is indemnification always granted?
No, it depends heavily on the circumstances and the outcome of the case. Indemnification can be mandatory, permissive, or prohibited. It's mandatory if the director is wholly successful in defending against the legal action on the merits or otherwise. If they win, the corporation must indemnify them for reasonable expenses. It's permissive, meaning the corporation may choose to indemnify but isn't required to. In other situations, typically if the director acted in good faith and with a reasonable belief that their conduct was in the corporation's best interest, or at least not opposed to it. This often applies even if the director settles the case or doesn't win outright, as long as they meet that standard of conduct. Disinterested directors, special legal counsel, or shareholders usually make the determination for permissive indemnification. However, indemnification is generally prohibited if the director is found liable to the corporation in a lawsuit, like a derivative suit for breach of duty, or if they're found to have received an improper personal benefit, or often if their conduct involved intentional wrongdoing or a crime where they had reasonable cause to believe it was unlawful. The system is designed to protect directors who act in good faith, while not shielding those who engage in clear misconduct or harm the corporation. Corporations can also purchase directors and officers, D&O, liability insurance, to cover situations where indemnification might not be available. And this whole area really forces you to distinguish carefully, doesn't it, between an honest, well-intentioned error in business judgment, which should be protected by the BJR, and a clear breach of duty like blatant self-dealing, usurping an opportunity, or just gross negligence where personal liability becomes a very real threat. It's that delicate balance the law constantly tries to strike, encouraging responsible risk-taking while ensuring accountability for abuse of power or neglect. For bar exam purposes, knowing precisely when the BJR applies, when it's overcome, the specific safe harbors for loyalty breaches, and the rules around indemnification, these are absolutely critical points to master.
Okay, so directors set the high-level strategy, oversee everything, and carry those heavy fiduciary duties. But who are the actual hands and feet on the ground, handling the day-to-day operations and executing the vision set by the board?
That's the primary role of the officers and, of course, the other employees of the corporation. A corporation's officers typically include positions like a president, often also the chief executive officer or CEO, one or more vice presidents, a secretary, and a treasurer, or chief financial officer, CFO. The specific titles and responsibilities can vary widely depending on the company's size and structure.
Who chooses the officers, and can they be easily removed?
Officers are typically elected or appointed by the board of directors. And importantly, unlike directors who are elected by shareholders for a term, officers generally serve at the pleasure of the board. This means they may usually be removed by the board at any time, with or without cause, although removal might trigger contractual obligations if the officer has an employment agreement. This gives the board significant control over the operational leadership, ensuring alignment with the board's strategic vision.
Do officers owe the same serious fiduciary duties to the corporation as directors do, like the duty of care and the duty of loyalty?
Yes, absolutely. An officer's duties of care and loyalty, and generally their right to indemnification as well, are the same as a director's. They're also considered fiduciaries of the corporation and must act in good faith, with reasonable care, and in the best interests of the corporation, free from conflicts of interest. The same standards apply to their conduct in managing the company's affairs.
What about their liability to outsiders, to third parties? If an officer signs a contract on behalf of the corporation, are they personally liable if the corporation later breaches that contract? Or does the corporate shield protect them too?
Generally, the corporate shield protects them. An officer is typically not personally liable to third parties for obligations incurred or actions taken while properly performing their duties to the corporation. Why? Because they are acting as an agent of the corporation, their principal, not in their personal capacity. The liability rests with the corporation itself.
But are there exceptions? When could an officer be held personally liable?
Yes, there are crucial exceptions. An officer may be personally liable if they acted outside the scope of their authority, or if they acted purely in their personal capacity, maybe signing a contract in their own name without indicating they were acting for the corporation. More significantly, they can be held personally liable if they engaged in purposeful tortious behavior. For example, if an officer commits fraud against a third party or personally participates in defamation or assault while on the job, their status as an officer doesn't shield them from personal liability for their own torts. The corporate shield only protects them for legitimate corporate actions undertaken properly within their authority.
Okay, that makes sense. How does an officer get the legal authority to take actions that bind the corporation in the first place? Is it just automatically based on their job title, like president?
Not automatically, although the title can imply certain authority. There are three primary legal bases for an officer's authority to bind the corporation in dealings with third parties. First, actual authority. This is authority expressly granted to the officer, either defined in the corporate bylaws, for example, the treasurer shall have authority to manage corporate bank accounts, or specifically granted by a resolution of the board of directors. For example, the CEO is authorized to sign contracts up to $1 million.
Okay, actual authority is explicit. What else?
Second, implied authority. An officer has implied authority to perform tasks that are reasonably necessary to carry out their expressly assigned duties and responsibilities by virtue of their status or position. A company president, for instance, generally has implied authority to hire and fire employees or enter into ordinary business contracts, even if not explicitly spelled out everywhere, because those actions are typically inherent in running the business day to day. This implied authority generally applies to matters within the scope of ordinary business, not usually extraordinary transactions like selling off a major division of the company that would likely require explicit board approval.
So, actual, implied.
Yeah.
What's the third?
Third is apparent authority. This is different because it arises not from what the corporation tells the officer, but from what the corporation communicates or manifests to the third party. An officer has apparent authority if the corporation, through its actions, or sometimes even its inactions, holds the officer out to third parties as having authority to bind the corporation, leading those third parties to reasonably believe the officer possesses such power. For example, if a company consistently allows a sales manager to sign contracts without board approval and third parties rely on this, the company might be bound by those contracts under apparent authority, even if the manager technically lacked actual authority. The corporation is stopped from denying the authority it appeared to grant.
And what about regular employees who aren't officers? Do similar principles of authority and liability protection apply to them when they act for the company?
Yes, the principles of agency law are quite similar. An employee can similarly act on behalf of the corporation to the extent of their authority, whether that's actual, implied, or perhaps even apparent, depending on their role and the circumstances. And like officers, employees are usually protected as agents from personal liability for actions undertaken properly within the scope of their employment and in accordance with their authority, as long as they disclose they're acting for the corporation. The concept of agency is central. As long as they are acting within the scope of their job for the benefit of their principal, the corporation, they are generally shielded from personal liability for the corporation's contracts or obligations arising from those actions.
Okay, so officers and employees are truly the hands and feet, executing the vision set by the board, guided by the articles and bylaws, and acting with various forms of authority. But, things don't always run smoothly. What happens when disputes inevitably arise, maybe between shareholders and management, or among shareholders themselves, or when the entire corporate structure needs to fundamentally change or even cease to exist altogether? Let's get into those dynamics.
Absolutely. This brings us to some of the more contentious and often legally complex aspects of corporate life. Handling internal and external legal challenges, understanding when that crucial limited liability shield might fail, and navigating the formal, often intricate processes for transforming or even ending a corporation's existence. These are situations where the underlying legal principles we've discussed are truly put to the test, often with very high stakes.
Okay, so when a shareholder feels wronged, maybe they think management is misbehaving, or perhaps the corporation itself has been harmed financially by bad decisions or misconduct. It's not always straightforward how they can bring a lawsuit, is it? I understand there are different types of lawsuits shareholders can bring, and that distinction matters a great deal.
Yes, this distinction is absolutely vital, and it's a frequent point of confusion, but also a critical area for legal analysis, especially for exams. There are two main types of actions a shareholder might bring related to the corporation, and understanding whose injury is being addressed is the absolute key to distinguishing them. The first type is a direct action. This is a lawsuit brought by a shareholder to enforce their own personal rights as an owner or to seek redress for a harm done directly to them.
Harm to the shareholder personally, like what?
Think of it as a shareholder suing because they were personally harmed in their capacity as a shareholder, distinct from any harm suffered by the company as a whole. Classic examples include suing to enforce their right to inspect corporate records if the company refuses, or trying to compel the payment of a dividend if they believe the board is withholding it in bad faith, or perhaps suing the corporation or its agents for a fraud that directly induced them to buy or sell their shares at a disadvantageous price. The critical distinguishing feature is that the recovery, if any, from a successful direct suit directly benefits the shareholder bringing the suit. The money or the remedy goes into their pocket or directly enforces their right.
Okay, that's a direct action harm to the shareholder, recovery to the shareholder. What's the other type of action? How is it fundamentally different?
The second type is a derivative action. This is fundamentally different because in a derivative action, the shareholder is not suing for their own direct harm. Instead, the shareholder sues on behalf of the corporation itself to seek remedy for a harm suffered by the corporation.
So the shareholder is acting for the company.
Exactly. The shareholder is essentially stepping into the shoes of the corporation to assert a legal claim that the corporation itself theoretically possesses,
but has failed or refused to bring, perhaps because the people who caused the harm, like directors or officers, are still in control of the corporation and are unlikely to sue themselves.
What kind of harm would trigger a derivative suit?
Typically, it involves breaches of fiduciary duty by directors or officers that damage the corporation financially. For instance, if directors approve a disastrous merger without proper care, breach of duty of care, or engage in self-dealing transactions that drain corporate assets, breach of duty of loyalty, and the corporation suffers significant financial harm as a result, a shareholder might bring a derivative suit to recover those damages for the corporation. The key distinction here, and you really cannot overstate its importance, is that the recovery from a successful derivative suit benefits the corporation, not the individual shareholder plaintiff directly. Any monetary award or other remedy goes back into the corporate treasury, theoretically benefiting all shareholders indirectly by making the corporation whole again.
That's a huge difference in where the money goes. So if I'm a shareholder and I want to bring one of these derivative actions acting on behalf of the company, what are the specific hoops I need to jump through legally? It sounds like there might be some strict procedural rules to prevent frivolous suits.
You're right. The standing requirements for bringing a derivative action are indeed quite specific and must be meticulously followed. Courts impose these hurdles to ensure the suit is brought genuinely for the corporation's benefit and not just for personal gain or harassment. Typically, the shareholder plaintiff must meet several conditions. 1, they must have been a shareholder at the time of the alleged wrong, the contemporaneous ownership rule. You generally can't buy shares after finding out about some past misconduct and then sue over it. 2, they must still be a shareholder when the action is filed. 3, they must remain a shareholder continuously throughout the entire litigation process. If they sell their shares mid-lawsuit, they usually lose standing. 4, they must fairly and adequately represent the interests of the corporation and similarly situated shareholders. They can't have conflicts of interest that would compromise their ability to act for the corporation's benefit. And 5, this is a big one, they generally must first make a written demand on the board of directors, asking the board to pursue the legal action itself. The shareholder must then typically wait 90 days, unless the demand is rejected earlier or waiting would cause irreparable injury, before commencing the derivative action.
A demand on the board first. Why is that required?
This demand requirement is rooted in the principle that the board of directors, not individual shareholders, is primarily responsible for managing the corporation's business, which includes deciding whether to initiate litigation. The demand gives the board a chance to investigate the claims and decide, using your business judgment, whether pursuing the lawsuit is actually in the corporation's best interests. Maybe they conclude the suit is weak or too costly or would distract from more important business. Only if the board rejects the demand or fails to respond within the time frame can the shareholder usually proceed with the derivative suit. Though many states recognize a demand futility exception if it's clear the board is conflicted and couldn't possibly evaluate the demand impartially.
Okay, so standing rules, demand requirement. If the shareholder clears all those hurdles and actually wins the derivative suit, or maybe achieves a settlement that benefits the corporation, do they get reimbursed for their legal fees and expenses? Because it sounds like a lot of effort for a recovery that goes back to the company, not them personally.
Yes, that's a critical incentive mechanism. If the derivative action results in a substantial benefit to the corporation, which could be a monetary recovery, but could also be significant non-monetary relief, like forcing changes in corporate governance or stopping harmful practices, the plaintiff shareholder can typically petition the court to order the corporation to reimburse their reasonable litigation expenses, including hefty attorney's fees. This fee shifting encourages shareholders with legitimate claims to act as private attorneys general to police corporate misconduct when the board won't.
But it's not a guaranteed win for the shareholder plaintiff, right? Can the board fight back against the derivative suit itself?
Absolutely. Even after a derivative suit is filed, perhaps after demand was made and refused or excused as futile, the board hasn't necessarily lost control. The board can often appoint a special litigation committee, SLC, composed of disinterested, independent directors, sometimes newly appointed ones, to investigate the claims raised in the derivative suit. If this SLC, after a thorough and good faith investigation, determines that maintaining the lawsuit is not in the corporation's best interests, the board can move to dismiss the case based on the SLC's recommendation. Courts give varying degrees of deference to these SLC decisions, but it provides a significant procedural defense for the corporation against derivative suits the board deems harmful or unwarranted.
And one final check. Can anyone else, like a creditor who the corporation owes money to, bring a derivative action if they think the directors are mismanaging the company?